Alright, hi, Title 40, 29, Part 29, Code for the Regulations, Apprenticeship Agreement 29.7. Received three comments on the proposed 29.7 regarding the requirement of the apprenticeship agreement to now with the voice. Advocate for the major change of the produce provision of the proposed change, update the terminology to align with the apprenticeship agreement with the three approach of the apprenticeship, the progression time-based, competency-based, and hybrid, and it's based on the agreement on which the apprenticeship would voluntarily provide with the Social Security for the number that the registration agency will use the apprenticeship Social Security number for the performance management of the Davis-Bacon Act purpose in the particular use of the calculating employment outcome for the National Apprenticeship System as defined with the Department of Common Measure for the Federal Job Training Program. The department has approved the information collection request for the use of the Social Security number information of an apprenticeship agreement operation Office of Management and Budget Control number 1205 020 0223. The commentator suggested that the proposed change will result in an undue time and financial burden with the state apprenticeship agency. To accommodate the suggested additional requirement for the collection of the equal employment opportunity information which are beyond the scope of the provision of Part 229 or Part 29. Response: while revision forms will require the expenditure of the resource of the change, resulting revision for the form of the minimal, the more over the change of the necessary for the national apprenticeship system to continue with the aligning with the change of the approach for the on-job learning as well as the broad with the environmental with which the apprenticeship of the program operate with a note with the non-discrimination provision. Statute 29.7 are limited to the prohibition for their applicable under the Part 30 with the regulation of the equal opportunity and apprenticeship training do not describe the full range of equal opportunity protections that may be applicable to the registered apprenticeship program. Registered apprenticeship programs are subject to other federal, state, and local laws, regulations regarding equal opportunity in employment and training, such as the American Disability Act, the Age Discrimination Employment Act, the Title VII, with the Civil Rights Act of 1964. Upon further review, we determined that there are three minor main changes necessary aligned with the section revision of the definition standard of the apprenticeship discussed above, with the deletion of the definition supplemental instruction discussed above, and the discussion of the definitions of the term is no longer appropriate for the requirement of the statute 2970E2 regarding number of hours related instruction. We have revised 27E 2 accordingly for the consistency final of the 29.5 by B2 to B22, which specifies the competency base for the program still required with the apprenticeship complete with the on-the-job learning component of the registered apprenticeship. We have revised the requirement of the 29.7E with the competency base of the programs to include the statement about the on-the-job learning. We also have replaced the term school time in the 27G with appropriate term related instruction to describe whether or not the appropriate apprenticeship is compensated during the related instruction component with the registered apprenticeship. Deregistration registered programs. Section 29.8 clarify with the provision of registration, registration apprenticeship programs. We have corrected the mistake with the proposed 29.8B1, replacing and with or to clarify the registration agency more undertake the deregistration procedure for when the program is not conducted, operated, administrated in accordance with the program registered provisions of the requirements of Title 29 CFR Part 29. Five common areas of the draft of the proposed change of the statute 29.8 with the clarify of the existing 29.7 the provision with the deregistration of the apprenticeship program. One commentator requested clarification as to whether the program would automatically enter the deregistration process if it without any apprenticeship for more than 15 or more days. Two components expressed concern with the department's ability to sufficiently address the burdens associated with the deregistration procedure, but emphasize that the deregistration should be conducted with the local level rather than federal level. The three commenters asserted the proposed rule would usurp power with the state apprenticeship program response to the program that is without the apprenticeship for the 15-day but not subject to deregistration discussed with regard to the program performance standard above the revised 29.6A with allowing the time lag of up to 1 year between the train cycles during which the program could without registered apprenticeship to address the ambiguity regarding the relationship between the failure to meet the new program performance standards established in 29.6 with the requirements of the deregistration of the registered program established in 29.8. We also have revised the final rule 29.8B1 to clarify the circumstances with the registration proceeding may undertake the failure to conduct operate, administrate with the program in accordance with the requirements of Part 29. The circumstances include failure to meet the long-standing standards of the National Apprenticeship System, such as the failure to provide on-the-job learning, failure to provide related instruction, failure to pay the apprenticeship as progressively increasing schedule with the wages consistent with the apprenticeship skill, with addition persistent with a significant failure to perform successful under the new performance standards established in Section 29.6 may also lead the deregistration. However, the persistent significance to failure to perform successfully does not occur simply when the program's completion of the rate of falls below the national average of deregistration proceeding applied with the program with the serve of the performance program. Persistent significant failure to perform successful occurs with the program sponsor consistently likely fails to register at least one apprenticeship should a pattern poor quality assessment results over the period of several years demonstrating an ongoing pattern of very low completion rates over the period of several years show no indication of improvement in the areas identified by the registration agency during the review process requiring corrective action. With regard to concern about the burdens associated with the deregistration procedure usurping power over the state apprenticeship agency, Statute 29.8 deletes the term Bureau or Office of Apprenticeship Registered Program and use the term registered agency to clarify that program. Deregistration procedure outlined with the Statute 29.8a and b are conducted with the state level registration agency, with the state apprenticeship agency, with the deregistration procedure conducted by the state apprenticeship agency, and such proceeding would be required to comply with the Statute 29.8. We emphasize the following: 29.8 carried with the forward existing practice that has evolved the current regulation and with the department has deferred the recognized state apprenticeship of the agency authority with the matter of the program deregistration. Therefore, the department anticipates having sufficient resources to address any burdens associated with the deregistration procedures, as these matters will primarily pertain with the deregistration procedure for the state where the department of the registration agency. Final Statute 29.8b and 7 to clarify that the sponsor request for the hearing administrator refers to the matter of the administrative law judge who convey the hearing and issue the decision according with the Statute 29.10c, with this clarification aligned with the final rule with the Secretary's Order 1, 2002-67, Federal Register 64272. October 17, 2002, which provides an administrative law judge decision and program to deregistering is only subject to the discretionary review by the Administrative Review Board. Reinstatement of the program re-registration. The Department received one of the comments of this section. The commenter agreed with the proposed text of the reinstatement of the program registration. Response: we are promulgating the final Statute 29.9, our proposed hearing for the registration. Statute 229.10. Four commenters addressed the proposed change with the 229.10 with the requirement of the deregistration hearing is one of the commenters agreed with the proposed change with another commenter approved the provisions in this section on the basis that the hearing of the deregistration should be kept at the state level. Third commenter asked if this section applied to the programs registered with the state apprenticeship agencies. Another commenter indicated that the public had not been allowed sufficient time to review the Office of the Administrative Law of Judges hearing the rules Title 29 CFR Part 18, which will apply with the deregistration hearing. This commenter also suggested that the proposed changes to the method of appealing existing 29.9 would reduce access due to process law. The commenters suggested that the hearing before the administrative law judge is established in 29.10 to differ considerable from the proceeding before a hearing of officer over the trial by jury. Response: we disagree with the commenter's assertion with the administrative law judge procedures would reduce access due to process, and that the public has not allowed the sufficient time for the review of the Office of Administrative Law Judges hearing the rules Title 29 CFR Part 18. The applicable rule procedures of Title 29 CFR Part 18 provided with the uniform rule for conducting the hearing with the wide range Department of Labor program. But the rules are consistent with the Administrative Procedure Act, the requirements for the conducting agency injunctions. However, upon review further, we have determined that if it's more appropriate for the notice for the Administrative Law Judge to refer to the request as request for the hearing rather than request for the review as proposed in the National Practices Review, or NPRM, which revised in 2910B accordingly. We disagree with the commenter's assertion for the hearing of the reinstatement of the program registration should be kept at state level under existing 29.9, but such hearings are conducted at the federal level. Finally, 2910 merely changes the federal official conducting the hearing. We note that the requirements for all the hearings of deregistration apply to all the programs that have been registered for the federal purpose, regardless of whether the program is registered with the Office of Apprenticeship or the federal purpose whether recognized by the state apprenticeship agency. Expected as noted, we will promulgate the final Statute 2910 as proposed. Limitations 2911 to complaints in 2912. 2911 limitations complaints 2912. One comment received that each of these proposed provisions, both expressing support, the department will promulgate the statute 2911 and 2912 as proposed. Recognition of the state apprenticeship agency 2913. Proposed in 29 and 13 revive the provision existing in 2912 that address the recognition that the state apprenticeship agency for the federal purpose clarifies how the Office of Apprenticeship oversee the national apprenticeship system. We received the 125 comments for the section overall, 110 which were addressed specific provisions including limiting recognition of the state apprenticeship agency role of the State Apprenticeship Council, linkage with the economic development, the workforce investment, the system location of the State Apprenticeship Agency, requirement of the source to carry out the function of the registered agency, reciprocal approval of the program, standard of the building of the construction industry, the department review and the approval of the State Apprenticeship legislation, regulations, policy, the operational procedure, application for the recognition, renewal of the maintenance recognition. Civil commenters strongly oppose the revision, asserting the proposed change of the overly perspective would significantly limit the state authority to oversee the registered apprenticeship functions within its jurisdiction. Its only responsibility to ensure the state recognized as having such authority continuing to confirm the federal requirements on which the recognition is based. Description below: the Department of Recognition for the State Apprenticeship Agency pertaining to the granting of the federal-state partnership in which the department grants state authority to act on the behalf of the registration agency. The provision in Part 20 and 30 of the set for the condition for the state to maintain the authority of these provisions are not meant to impact the state authority to regulate the apprenticeship for the state purposes. Alright, role of the State Apprenticeship Agency. The 12 comments focuses on the proposed in Statute 2913A with the provide with the recognition only of the State Apprenticeship Agency. Now the State Apprenticeship Council provide with the Department a recognition of the State Apprenticeship Agency confers not exclusively authority to determine whether an apprenticeship program meets with the published standard and is eligible for the federal purpose of which required for the determination. Such commentators asserted that these changes conflict with their states and current law, whereby the State Apprenticeship Council oversees the state apprenticeship system, promulgates the regulation of the oversee of the State Apprenticeship Agency work. Thus, proposed changes would require revision of the state apprenticeship law and regulation, and others suggest that the department should not dictate to the state and the nature and structure of their government. The response our experience has shown with the government-to-government relationship with the state apprenticeship agency facilitate smooth functioning of the national apprenticeship system, thus best protecting a apprenticeship interest. Although the members of the state apprenticeship council represent the diverse employer, labor, public, and interest, that have knowledge of the experience that enables them to be the strong advocate of the apprenticeship that many of them have no state official, many of them are not state official. Therefore, a member of the state apprenticeship council are not ultimately accountable to the state or department of their actions. Such as the accountability essential for the functional national apprenticeship system, especially where it becomes safeguarding with the welfare of apprenticeship, the promoting the apprenticeship of opportunity. State officials represent the interest of the entire state, and they are accountable for the exactions. Accordingly, our proposal to extend the recognition only to the state apprenticeship agencies necessary to ensure the entity that is held accountable for the conformity within Part 29 clearly identify the proposal does not dictate the nature and structure of the state government. It merely identifies the state government entity to which the department will grant authority to act on the behalf of the registration agency. The existing regulations do not specify the recognized registration agency must be a governmental cabinet level agency. Changes to the Statute 2913A clarify the requirement to further the line with the proposed regulation for National Apprenticeship System with the National Apprenticeship Act, with which the State Department is to cooperate with the state agencies engaged with the formulation and promotion of the standards of apprenticeship. Therefore, we have made no changes in Statute 2913A1. Role State Apprenticeship Council. We received the 20 comments regarding the proposed Statute 2913A2 with the provision of the State Apprenticeship Council. Several of the commenters will serve with the current with the role responsibility for the State Apprenticeship Council. State Apprenticeship Agency work well. And question needed to adjust for the system mainly expressed with the concern with eliminate the State Apprenticeship Council. One commenter suggested that removing the State Apprenticeship Council's decision-making role would significantly reduce the level of participation for the key stakeholders, potentially creating far-reaching negative effects for the apprenticeship program. And another commenter questioned why they propose regulations that do not apply with acceptable state and apprenticeship council membership that is provided with existing Part 29. Our response is described above would determine the effective function of the federal-state partnership with the registered apprenticeship system with required the direct relationship with the federal and state agencies. However, we will no longer recognize state apprenticeship councils for registration purposes. We will not eliminate the requirement of establishing a state apprenticeship council for the regulatory and advisory purposes. Members of the State Apprenticeship Council will continue to be critical stakeholders who actively participate in essential for the successful operation of a registered apprenticeship program that is in their state. Based on a new organizational system, we're limiting the direct regulation for the requirements applicable to recognize the State Apprenticeship Agency. Given the final rule, recognize the State Apprenticeship Agency responsible for the registered apprenticeship for the federal purpose of their state will determine that it is appropriate for the such registration agency to direct the operations of the corresponding state apprenticeship of the council. Accordingly, we have revised Statute 2913A to clarify the state apprenticeship council operates under the direction of the state apprenticeship agency. We reiterate that Statute 2913A2, 1 and 2 carry the forward provision of the existing regulations pertaining to the state apprenticeship council's membership criteria as expected. As noted, we are promulgating Statute 2913A as proposed. Linkage with economic development and workforce investment. The two commenters asserted that the department lacked the statutory authority to require the mandate of the state apprenticeship agency integrate with the state economic development strategy of the public workforce investment system as provided in Statute 2913A6. Another commenter supported the provision of the suggestion of the department also should encourage the registered apprenticeship program to develop agreements with the community college. Response to the National Apprenticeship Act abroad mandated the self-guard welfare apprenticeship full authorized to propose requirement of the integration registered apprenticeship with the economic and workforce development efforts. The requirement is part of the broader trend among federal state workforce development programs to increase the coordinated across the program in an effort to more effectively meet the need of the business worker with the regional area as part of the workforce investment system. Registered apprenticeship programs should align with the closely regional coordinated with the talent development strategy aimed to provide working with the 21st century skill of the business industry demand. However, upon review, will we conclude that the terms proposed in Statute 2913A6 regarding the linkage coordinated with the economic development and the workforce investment system fit within the proposed 2913A4, which pertain to the basic standard criteria of requirements of the program registration and/or approval. Therefore, proposed 2913A6 that has been consulted with the 2913A4. Further, we revised terminology that refers to the workforce system that should include the phrase publicly funded workforce investment system to clarify the public funding can support with the linkages and coordinate with across the state apprenticeship agency of the state workforce investment economic development strategies. This revision aligns with the effort to expand apprenticeship in the high growth, high demand occupations. Location and state of the apprenticeship agency. We received the 10 comments opposing the proposed deletion of the existing 2912B1 of the state, which sets the requirement of the location and state of the apprenticeship agency and the state department of the labor, the agency of the state government having the jurisdiction of the laws, regulations governing wages, hours, and working conditions. 8 commenters suggested that relocating the state apprenticeship agency would likely diminish the safety, health, and welfare of apprenticeship in the workplace. One commenter stated that the result of the rule changing for the apprenticeship program could be placed in within the department or the division of the state government that is not familiar with the qualified to address the issue pertaining to the registered apprenticeship. Another commenter stated that the rule changed the counter to the integration of the apprenticeship into the public workforce development system and work interfere with the seamless integration of work protection consideration. One commenter stated that as a result of the rule change, the apprenticeship program could be placed within the department or division of state government that is not familiar with or qualified to address issues pertaining to registered apprenticeship. Response. We disagree with the proposal of the deletion of the regulatory provisions specified with the location for the state apprenticeship agency will negatively impact the welfare of the apprenticeship. That if it counters the efforts to integrate with the registered apprenticeship with the public workforce development system, the historical registered apprenticeship function has resided in the area of the state government that oversees the ways of the house or hours function, and this approach of the function very well with the most states. However, many states governments have reorganized, and the various state governments function differently. In light of these organizational changes, the final rule affords flexibility necessary for the state to determine the most appropriate location of the registered apprenticeship based on the organizational configuration. Regardless of the location, recognized state of the apprenticeship agency still must meet the requirements of this part, including the provisions of statute 29.5 of the safeguarding the welfare of the apprentice, and then the provision of statute 2913A4 of requiring the demonstrating a linkage with the state economic development strategy for the public workforce system. Further, the effective function of the federal-state partnership of the registered apprenticeship does not require the specificity for the regionalized organizational location of the state government agency. Resources. Proposed in Statute 2913B with the requirement for the state apprenticeship agency to provide sufficient budget for the state staff to carry out the functions of the registered agency, also generated with considerable option. 4 comments stated with the proposed requirement of Statute 2913B2 with the worthwhile guideline for the registration agency asserted that the department does not allocate the sufficient staff budget to carry out the responsibility of 25 states where the Office of Apprenticeship is the registration agency. 4 commenters indicated that the department does not have the authority to dictate budget mandates to the state. The response: the department is currently with the registration agency in 25 states, provided with the dedicated staff the resource sufficient to fulfill its responsibility of the registered apprenticeship of the federal purpose in these states and other 25 states where they are conferred recognition to the state registered apprenticeship and apprenticeship program for the federal purpose of the current regulations is or responsible to ensure that we provide recognition for the state that the dedicated with the necessary resources for the search function of the proposed rules provision sufficient resources do not dictate the budget mandates. The responsibility of establishing the budget mandates remain the state government. However, we've been persuaded by comments that it is more appropriate to use the language that is less prescriptive and allocate sufficient budget and staff to describe the registered agency will address for the function. Therefore, we have revised the final rule 2913B2 with required simply with the state provided with sufficient resources to carry out the function of the registration agency. In the final rule, the provision establishing the function of the registration agency will include outreach and educational registration programs, the apprenticeship, provisional technical assistance monitoring is required to fulfill the requirements of the part of the unchanged reciprocal approval. We received 38 comments about proposed 2913B7, which expand with the current provision of the reciprocal approval, eliminating the exception for programs and standards in building and construction industry. The nature of the components opposed the proposal. Many of the request the Department of Labor to reinstate the exemption of the building and construction industry. Two commenters asked the Department of Labor to clarify the exemption that were originally granted, while they proposed revision would eliminate the exemption. How this act will impact the related regulations, such as those pertaining with the federal works project subject to the Davis-Bacon Act. More than a dozen commenters raised the issues associated with the variation among the state apprenticeship age requirement of the program registration. One set of the commenters addressed with the variation of the wage rates as sort of the unfair, economically disruptive. They allow the trades of one state with the use of the pay scale for their own state with the work of the state, particularly with the apprenticeship employed on the object project subject of the Davis-Bacon Act. For the other commenters who serve with the state have different quality of the training hours and license standard with which the proposed fail to recognize. And commenters stated that the proposed rule lacked language of the required visiting of the sponsor registered in another state to meet the existing local requirements for the apprenticeship of the registration state that asked the Department of Labor to clarify whether the host state law, the home state laws would apply with the apprenticeship. In response, the exemption of the reciprocal for the apprenticeship program of the construction industry of the current regulations was based on the view of the seasonality of the construction work would potentially interrupt the apprenticeship on the job learning, require the apprenticeship be supervised with several employees, require the provision related instruction in several places rather than one location, thereby negatively impacting the quality of the apprenticeship program in the construction industry, which advances to the technology to assist the provision related instruction, supervision, and apprenticeship. The department believes that these agreements are exempt in construction industry programs. The reciprocal approval no longer valid. The particular use of electronic media related instruction as permitted in statute final 29.2 will provide for the construction apprenticeship program while the inability to ensure consistency of related technical instruction across the country, regardless of the geographical location. High quality standard for the apprenticeship programs can be attained in the construction industry regardless of the seasonal nature of the construction work. Therefore, the extension of the reciprocal approval of the construction industry of the program as well as the non-construction program will enable the national apprenticeship system to further address the apprenticeship need for the business and labor. We acknowledge the commenters have raised important concern for the difference between the home states and the host states requirement. The provision in Statute 2913B7 was intended to provide the program sponsor register of the program for the federal purpose of one state with the fairness of the contracting bidding on federal public work projects in another state with the subject of the Davis-Bacon Act while still safeguarding with the welfare registered apprenticeship. We agree with the application for the home state wage and hours apprenticeship ratios in the host state can confer with the unfair advantage for the out-of-state with the contractor bidding on the federal public works project. Such an outcome will be unacceptable. This will why in all the instances where having negotiated memorandum with the state and recognizing state to arrange the reciprocal approval of the apprenticeship programs in the building construction trade, we have consistently required that the wage and hour apprenticeship ratio. Requirement of the host state applied with the state federalism section of the administrative requirement to discussion in the NPRM. Extension of the reciprocal approval of the construction industry program that allow for the state registration agency to retain the authority to enforce state labor law for such provision covering the apprenticeship wage and rates ratios. Further, the explanation we have added the language of the final rule to clarify that the program sponsor seeking reciprocal approval must comply with the host state wage and hour apprentice ratio standards, with the clarification final with standards 2913B with the 7 with the prohibits out-of-state program sponsors seeking reciprocal approval of the host state from the beginning with a competitive advantage for the registering and operating an apprenticeship program. The federal purpose of extension of the reciprocal approval of the final Statute 2913B7 will not impact the state implementation regulations pertaining to the federal work projects such as the Davis-Bacon Act. We further emphasize the final of the Statute 2913B7 that does not address the other aspect of the state legislative, regulatory, procedural requirements for the registered apprenticeship of the state with a local purpose, because in Part 29 pertaining to the registered apprenticeship with the federal purpose is issued with such licensures requirement of the contribution, state apprenticeship training, funding, and our state purpose if it is not covered by the requirement of the reciprocal approval, and for federal purposes and final statute 2913B7, the state apprenticeship and legislation, regulation, policy, and operational procedure. 27 of the commenters expressed concern about the proposed in 2913B9 with the explicit requirement of the state apprenticeship agency to submit the proposed modification of the state apprenticeship legislation, regulation, policy, operational procedure for the Department of Review and approval prior to the implementation of the conformity with the National Apprenticeship Act, the implementation regulation in Title 29 CFR Part 2930. Many comments expressed the concern with the proposed in 2913B with ignores the state authority to set policy, establish the laws to meet the unique needs of the industry and the citizen. One of the commenters observed that these changes usurps the state's authority exceed the authorities granted by the National Apprenticeship Act. The other commenters asserted that the Office of the Apprenticeship required review will inhibit the state regulatory process and decrease state governmental response to the public. The response: given the National Apprenticeship Act, the broad mandate of the Department to safeguard the welfare of the apprentice, with the proposed requirement of the Department of Review prior to the implementation of the state revision and proof of the apprenticeship law with the authority under the Act. The further requirement is necessary for the Department of Management of the National Apprenticeship System, for it is permitted the registered apprenticeship of the apprenticeship program for the federal purpose. The state wishing to participate in the National Apprenticeship System must submit the apprenticeship to the law with the other information 2913A and B to the Department, determining that they are confirmed with the requirements of the federal apprenticeship law with the state apprenticeship agency. Responsible to the federal law with the design and there the rather recognize the state apprenticeship agency continue to conform with the requirements of the federal law, particularly where the agency wants to make the change to their own law with regulation. Recent experiences with the review of the recognized state with the apprenticeship agencies has underscored the need for the department to monitor the state efforts for the modify the apprenticeship law and pertaining to the registered apprenticeship for the federal purpose. Office of Apprenticeship Review that have repeatedly identified provisions with the state and laws of regulation that were not consistent with the federal apprenticeship law. This has led to our requiring state apprenticeship agencies to take the corrective action necessary for them to attain conformity with the Parts 29 and 30 of the National Apprenticeship Act. Notice the Office of Apprenticeship the opportunity for the review of the proposed change of the state of the apprenticeship law with the regulation policy are necessary for the Department of Oversight. However, the effect of the purpose of the proposed statute 2913B9 will be facilitated with the Department of Management of the National Apprenticeship System. Note that not the usurp state authority to establish state law and policy. Accordingly, in recognition of the concern raised by the commenters, we have revised statute 2913B9 to provide the state must submit all the proposed modifications in the apprenticeship legislation, regulation, policy, an operational procedure for the Office of the Apprenticeship Review and concern with rather than approval the Office of Apprenticeship concerned with simply reflect with the finding of the proposed modification conform with Part 29 of the implementation proposal will not affect the state recognition status for the Office of Apprenticeship. The finding for the proposed modification does not conform with Part 29. It will notify the state in concerning with the work with the state, resolve them, provided with the technical assistance as appropriate. It will provide with the state and Office of Apprenticeship with an opportunity to identify the work on the issue with the potential effect of state recognition status before the proposal takes effect. Must be undone to preserve recognition. The state will be notified with the Office of Apprenticeship findings as conform with 45 days of the date of the Office of the Apprenticeship to receive the proposed modification as provided with the statute 2913E4. Although the process for the Office of Apprenticeship Review with the concurrence with the state apprenticeship legislation, regulation, policy, and operational procedure may be extended with the time necessary for the modification, potential impositions for the additional time justified with the need to ensure the revision of the state apprenticeship law, regulation, policy, procedure conform with the Part 29 and 30 National Apprenticeship Act. The registration agency can help to maximize the efficiency provided for the modify the department any of the modification under the consideration earliest opportunity for the states to proceed with the revision prior to the completion of the Department of Review concerned with the process can minimize the disruption that would result from the subsequent department non-concurrence through the conclusion of the saving clause, such as the clause example to provide the text from which the supersede of the modification to which the department did not occur or place on the reader or notice that the revision would take effect only if and when the department concurred with the change. Application of recognition. Three commenters raised the concern about the proposed in statute 2913C with the establishment of the requirement for the state apprenticeship agency to apply the recognition for the department. One commenter suggested the state apprenticeship agency recognized by the department under the current regulation should only be required to renew the status and not apply for the recognition. Another commenter asserted that the requiring state apprenticeship agency to reapply recognition of diverse resource for the program implementation would interfere with the funding of the budget and planning in another state. Another stated that the Department of Labor currently with authority with the withdrawal of the recognition of the state apprenticeship agency fails to conform with the part. There's no need to play for the further reporting of the oversight with the requirement of the state apprenticeship agencies to reapply with the recognition within 1 year of the effective date of the rules. Response: the rule It significantly revived the substantive provision of Part 29, although the reapplication process of the recognition required the resource to prepare all submittable materials was specified in Statute 2913C was determined that if absolutely essential to ensure the state of the apprenticeship agency can comprehensive to conform to renewed requirements of Part 29 precondition recognition. However, we acknowledge the adequate and reasonable response to the new requirements will likely require more than 1 year provided with an NPM or NPRM. Therefore, the final Statute 2913C establishes a 2-year time frame for the effective date of the final rule for the currently recognized state seeking the continued recognition for the submit with the required documentation. Document the Office of Apprenticeship. The means the state seeking the continued recognition will have 2 years from the effective date of the final rule to make any changes necessary for the compliance with this part. We also recognize that the circumstances may arise with the provided good cover the extension of the 2 years of the time frame. Final Statute 2913C carries the forward proposed provision that allows the state to submit written requests to the extension of the time for which to be complied with the requirements of the part expected as noted. The final Statute 2913C is promulgated and proposed. A real renewal and maintenance of the recognition. 5 commenters addressed the proposed Statute 2913, which established a 5-year period of recognition for the state apprenticeship agency by the department that provided the process of renewal rate if the recognition for the 4 commenters state that the Department of Labor currently has the authority to withdraw recognition for the state apprenticeship agency if it has failed to conform with Part 29, so that there is no need to place further requirements in the state apprenticeship agency to renew their recognition every 5 years. 1 commenter asserted that requiring state apprenticeship agency to renew the recognition of diverted resources from the program implementation would interfere with the funding of the budget and planning. Existing regulations confer one on and the recognition for the state apprenticeship agency for federal purposes do not clearly specify. State apprenticeship agency must continue to meet the regulatory requirements to continue with the recognition. The department conferred with the recognition for the state apprenticeship agency to register the apprenticeship program. The federal purpose is our responsibility to ensure that the basic recognition of the state apprenticeship law, regulation, policy, and plans. The procedure continues to conform with the federal requirements. We anticipate the periodic changes as state apprenticeship agencies respond to the changing workforce needs in business, industry, and labor. Section 2913D of the establishes the requirement for the renewal of the maintenance of the recognition to ensure the department has opportunity to review and determine if the state apprenticeship law of the regulation, policy, and plan of the procedure continues to conform with the federal requirements. If the Department of Review of the 5-year period provides a reasonable level of continuity, the State Apprenticeship Agency will provide an efficient way to ensure the State Apprenticeship Agency will remain in conformity with the federal requirements as discussed in the NPRM. The monitoring review, the outline Section 2913E will form the basis for the Office of Apprenticeship discussion whether the continuing recognition every 5 years. Therefore, the reporting with the State Apprenticeship Agency for the first year for the 5-year renewal with the maintenance recognition will be minimal. We'll have revised final Section 2913D to clarify the notification. States regarding conformity with this part will be based on the Office of Apprenticeship Monitoring of the State Registration Agency compliance as provided in Statute 2913E. We also revised the 2913D accordingly. Compliance. No comments were received on the proposed 2913E, and which new provision provided with the on-site review of the self-assessment monitoring of the state apprenticeship law and the procedure is based on the department's existing procedure for the determining state apprenticeship agency complying with the Part 29. However, upon further review, we noted to not substantive changes were necessary to correct grammatical errors. We have provided the final 2913E with accordingly accountability remedy for the non-conformity. One of the comments received on the proposed statute 2913F with the new provisions, which provide the steps to be taken with the state apprenticeship agency to found to be out of compliance with the part of the 29. Those steps, which are based on the department current practice for the compliance of systems, include the provision technical assistance, which problems are found with conferral with the condition recognition for the 45 days. The state apprenticeship agency must submit the corrective action plan to remedy the conformity activity failure to maintain compliance. The commenter suggests extending the period of the conditional recognition to the 90 days, asserting that additional time must be necessary. Change the state law was found to be out of conformity with the Title 29 CFR Part 29. Response. We disagree with the recognition that extend the period of the conditional recognition for the 90 days period of the conditional recognition established in Statute 2913F2 with the pertaining to the time frame during which the apprenticeship agency must submit the corrective action plan. Paragraph F2 does not establish the time frame which the state must actually remedy for the nonconformity of the activity. The 45 day of the year period is consistent with the current practice to provide sufficient time to submit the corrective action plan. However, upon further review, we have noted that the requirements of the submission for the corrective action plan did not specify what the corrective action plan should be submitted. Therefore, we have revised Statute 2913F to clarify the state apprenticeship agency that was placed in conditional recognition must submit a corrective action plan with the Office of Apprenticeship that would deny the state apprenticeship agency recognition. No comments reviews received on the proposed statute 2913G with the based on the existing 2912Z with a simplified, clarified the process of determining whether the denial of the state apprenticeship agency recognition provides the procedural for the review of the decision. That, with the upon the further review, we have determined that further clarification was needed with regard to the information in the state apprenticeship agency about a request for the administrative review of the denial of recognition. We have revised statute 2913G to clarify the written notice due in a the state apprenticeship agency denying recognition for the must also specify the request for the administrative review of the denial of recognition may be made within the 30-day calendar date to receive the denial. This for the denial of the department. We also have added the provision in paragraph 4 to clarify the administrative review board must be decided in any case if they accept the further review within 100 days of the close of the record of this is not decided with the administrative law judge decision constitute a final agency action. This clarification aligns final with statute 2913G with the provision for administrative review and final statute 2910C. Our state apprenticeship programs. No comments were received on the proposed 2913H with care within the forward provision registration for the Office of Apprenticeship in the event of the state apprenticeship agency is not recognized for the Office of Apprenticeship for the federal purpose as such for the recognition has been withdrawn. That no state apprenticeship agency exists for the section 2914E with also established requirement with the registration with the Office of Apprenticeship for the program sponsored with effective with the derecognition of the state apprenticeship agency to avoid duplication of final rule. We have depleted the purpose of 2913H2 and revised the final 2914E to incorporate the provision proposing 2913H2 for an opportunity for the program sponsor to request registration for the Office of Apprenticeship where the state of the apprenticeship agency does not exist. The state apprenticeship agency is not recognized by the Office of the Apprenticeship for the federal purpose. No comments were received on the proposed 2913I and 2913J. Therefore, we're promulgating 2913I and 2913J for the proposed derecognition of the state agency. The department received the comment proposed the revision of the rules of debt derecognition for the state apprenticeship agency existing 2913 proposed in 2914 with the commentary were generally supported with the department proposed change for 2914 suggested new penalties such as clarification federal funds will be withheld from the state apprenticeship agency that unfairly restrict apprenticeship opportunities in a manner inconsistent with the Part 29 and 30 with the National Apprenticeship Act. The response of the commenter did not provide sufficient justification for the establishment additional penalty beyond derecognition. Further, and since the department provided no funds to save the apprenticeship agency, the department does not have the statutory authority to withhold the federal funds of the state apprenticeship agency. Upon further review, we also have added provision statute 2914C3(1), clarifying the administrative review board may just decide any of the cases except for the review of the 100 days. A day for the close of the record that is not decided with the administrative law judge. The decision constitutes final agency action. The clarification aligned with the final statute 2914C with the provision of administrative review in statute 2910C. As discussed above in 2914E, that has been revised to incorporate the provision of the program sponsor for the request of registration and office of apprenticeship where the state apprenticeship agency does not exist. The state apprenticeship agency is not recognized by the office of the apprenticeship of the federal requirements. Alright, we're going to cut the tape and leave section 3 for tomorrow. Administrative requirements for the rule. Executive Order 12866.